Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Welcome back to the podcast channel with degroots.com.au, and we're joined again with Max Williams, and we've got a good follow through from the last podcast that we did, and the question now is, what actually is a valid will?
Thanks, Tony. Yeah, so a valid will has to be valid with two requirements. So one is what we call formal validity, and each state has its own legislation. As we've talked about many times now in this podcast, each state has different wills and estates legislation, but they're pretty much all uniform in the sense that for a will to be formally valid, it needs to be in writing, needs to be signed by the person making the will, and their signature needs to be witnessed by two people who saw that person sign the will in their presence, and then the witnesses themselves also need to sign in the person making the will's presence. And if those things have been attended to, then the will is what we call formally valid. Now, there are also other aspects to validity which we call essential validity, and that deals with things like whether the person making the will has the capacity to make a will, or whether they actually knew and approved its contents. But we can probably talk about that in a future episode.
Right, great. So let's talk about the proverbial will made on a napkin. And is there actually any way of making that valid?
Yeah, potentially, Tony. So making a will that complies with the formal validity requirements, again, writing, signed, witness, is the cheapest and easiest way to make sure your wishes are followed. Because if you do that, it's going to get through probate generally, and then the executor can administer your estate. But sometimes that's not always the case. Sometimes people may have made a will on a napkin, or there's some more colourful examples. There's been cases where someone has recorded themselves on a video saying what they want to happen when they pass away, or they might have written something on their notes app on their phone. There's cases like that. What do you do then? Well, the legislation actually gives the court in the relevant state the jurisdiction to let those types of documents through. We call them informal wills, but only if certain criteria are established. So firstly, there needs to be a, quote, document. Now, the definition for document under the legislation is actually quite broad, so it encapsulates things like video recordings and computer documents and the like. And in most cases, there will be a document. The question then becomes whether that document contains the person making the document, whether it contains their, what we call testamentary intentions. And that simply means what happens to their stuff when they pass away. Is the content of that document to take effect when they pass away? If the answer is no, well, then it's not really a will, is it? Because a will, by its very essence, has to deal with the disposition of your estate when you pass away. And again, in most cases, that criteria will also be met. It's the third criteria where many of these cases will fall down. And that's where you have to establish that the person making the will, or the informal will, they intended the document to operate as their will. Now, sometimes that can be very difficult to prove, and you obviously need evidence, ideally from the person making the will, but by the time this gets to court, that person's dead, so you obviously can't ask them. And then you may interview people that they talk to. Did they send an email about the document saying, treating it as their will? Or did they send a copy to their solicitor and say, could you put it in safe custody? And that would evidence perhaps an intention that they intended it to operate as their will. So that's that third aspect of the testator's intention. The testator is just the legal term for the person making the will. That's the critical aspect.
Mm. Now, we have a post-COVID world and a modern world, and you were talking before about having a document signed. What about electronic signatures? How does that work?
Yes, unfortunately, that's not allowed at the moment. So in order for a will to be formally valid, it needs to be a wet ink signature, as do the signatures of the witnesses, because that proves, well, it at least initially proves, I think, that the will was signed in their presence, whereas an electronic signature obviously doesn't have that same level of proof. So the legislation doesn't allow for an electronic signature yet. I think it may come in the future, but as it stands today, you can't do that. And in fact, there was a case, I think it was last year in Victoria, where during COVID, someone had signed a will with DocuSign or the equivalent, and that was obviously an invalid will. And they had to go through that process of trying to get it probated under the informal will provisions. So you can, under some jurisdictions like New South Wales, have the witnessing of the signature happen via Zoom or other audiovisual methods. But again, that still requires a wet ink signature.
Yeah, I was going to ask you about that question. So you could potentially have a meeting with a lawyer online and then go, okay, we'll have other people joining in on the session. And then suddenly you think, okay, well, there's two of us that have said yes, you've written it and whatever, but it's still not valid.
Well, the witnessing has to take place online, but there needs to be a document that's signed. It needs to be a document in common with the other person witnessing it. So usually you would take the instructions online, go away, prepare the document. Maybe you email it to the person making the will, and they would print it. You would print it. You'd make sure they're the same version, and then the signing and witnessing can happen online with the cameras. But you wouldn't necessarily, I don't think you'd normally do that instantaneously, but you still need to go away and prepare the document.
Yeah. So already we're getting confusing about all of this, which is why you need to see a proper lawyer such as yourself.
And I would reiterate that, firstly, those special audio-visual witnessing provisions are not in every state. As I said, New South Wales has them, but not every other state does. And secondly, they really should only be used if you have them in your state, they really should only be used in very special circumstances. It shouldn't just because the client, couldn't be bothered to come into your office. Maybe they're bedbound or under isolation. I mean, that's, I think, why initially those provisions were introduced, because people, it was likely that people could be in isolation because of COVID. That's obviously not as relevant nowadays, but again, I think use it sparingly. I certainly, as we don't do that at our firm, I certainly wouldn't be using them for every case. It's really got to be special cases.
Thanks for that, Max. So we covered what is a valid will. Would you mind doing a quick wrap-up for us for this episode?
Sure. So, as I said, it's going to be much cheaper and easier for everyone involved if you make a will that's formally valid. So in writing, signed by the person making the will and witnessed by two people. However, if those requirements haven't been complied with, it's not necessarily the end of the road. And so you should see a lawyer, such as ourselves, to see if there's any possibility you could still get that document probated and essentially recognised.
Great. And at the beginning of the episode, you just touched on capacity. So the next episode, we're going to be talking more about capacity in relation to wills and estates.
Sounds good. Thanks, Tony. Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website, www.degroots.com.au, and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.